Bloomberg Audio Studios. Podcasts, radio, news.
This is Bloomberg Law.
Congress can have no say in making an office independent.
I think all agencies need a degree of autonomy.
It really tests whether the amendments to the law have teeth.
Interviews with prominent attorneys and Bloomberg legal experts.
Joining me is constitutional law professor David Super, Bloomberg News Supreme Court reporter Greg Storr.
And analysis of important legal issues, cases, and headlines.
Apple's a walled garden. They don't license their technology.
That is a valid basis to dismiss the case.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to the Bloomberg Law Show. I'm June Grasso. Ahead in this hour, the Supreme Court allows Trump to fire independent agency officials. An immigration law roundup, from challenges to ICE agents waiting in immigration court hallways. And do Geofence warrants violate your right to privacy? A 90-year-old legal precedent setting up independent agencies isn't dead yet. But after the Supreme Court's emergency order allowing President Trump to fire members of two independent agencies, the effect may be the same. The court's 1935 ruling in Humphrey's Executor said that Congress in some instances can set up agencies that are independent from the executive branch and whose members can only be fired for cause. But in recent years, the Supreme Court has significantly cut back on Humphreys. Over the dissents of three liberal justices, the court allowed Trump to fire National Labor Relations Board member Gwynne Wilcox and Merit Systems Protection Board member Kathy Harris without cause, as their legal challenges play out. My guest is Lauren McFerrin, Senior Fellow at the Century Foundation and former chairman of the NLRB in the Biden administration.
So what the Supreme Court did was stay an order of the district court, which had ordered the reinstatement of Gwynne Wilcox and Kathy Harris. And the removal of Gwynne and Kathy from office was clearly contrary to statute. The president is prohibited by both the National Labor Relations Act and the law governing the Merit Systems Protection Board from removing people from office except for cause, and no qualifying cause was given to either of these officials. So it was, the action was clearly contrary to law. And so the president kind of took the law into his own hands here and basically said, I don't care what Congress wanted, and I don't have to follow Supreme Court precedent, and he removed them from office anyway. The Supreme Court then stepped in and on what's called the shadow docket, which is supposed to be for emergency relief and emergency orders, indicated that the president was right to do that it is okay for him to ignore Congress and to ignore Supreme Court precedent, and kind of went to extraordinary lengths to keep that result in place because they basically think the president took a good gamble about their plans to revisit precedent. So it was very unusual from a court process perspective. The so-called shadow docket is supposed to be used for, like I said, emergencies. It's typically also used to preserve the doctrinal status quo, not to overrule it. You're certainly not supposed to use the shadow docket to effectively change precedent without the benefit of full briefing and careful consideration, which is what the dissent pointed out. So it was a procedurally very odd thing to do, but it certainly sent a very strong signal about where the Supreme Court is headed in terms of whether it plans to overrule Humphrey's Executor, which is the decision that had originally upheld Congress's ability to create positions like this that can only be removed from office by the president for cause.
So, according to the dissenting justices, the effect of this is essentially to overturn Humphrey's Executor.
I think that will be the practical read that a lot of people take away from it. Now, the majority did ultimately hedge on that question. The majority said that they're not ultimately deciding whether these two agencies fall within the recognized exceptions of Humphrey's Executor. That does suggest that there still will be some recognized exception, but they signaled pretty clearly that they didn't think either the National Labor Relations Board or the Merit Systems Protection Board would fall within that exception.
Tell us about Humphrey's Executor. It's sort of been on the way out, or people have been calling for its demise for a long time.
I mean, Humphrey's Executor, there's no question that it is still good law. The case that everyone cites for the proposition that Humphrey's Executor is on the way out the door is a case called Seal of Law. And Seal of Law was very careful to say that Humphreys still is good law and that they were not revisiting Humphreys. But what they did was that they certainly said they were not expanding Humphreys' executor to encompass independent agencies that aren't like the Federal Trade Commission that was the original subject of Humphreys itself. So they were unwilling to expand the reach of Humphreys' executor, this exception that allows Congress to create entities whose leaders can't be removed except for cause. They weren't going to expand that exception to a single-headed agency like the Consumer Financial Protection Bureau. But it is very clear that Humphreys, at this point in time, or at least until this order issued, that Humphreys itself, and the exception it creates for quasi-judicial and quasi-legislative agencies that are structured like a multi-member body, like the National Labor Relations Board and the Merit Systems Protection Board, still exists, and that exception is still valid.
The Supreme Court in recent years has cut back on Humphreys. I mean, it's still standing, but is it in sort of tatters?
I think it's safe to say that the court has constrained its reach and has at times, one or two justices in a separate opinion or in dicta in a majority opinion have called into question its continuing viability. Basically, this notion that there can be an entity, even if it is structured like a multi-member body, even if it is a body of experts that's supposed to make expert decisions, that there could be an entity like this that would not be sufficiently executive in the nature of the powers that it is exercising, such that its leaders should not be removable by the president. And that's the core issue here for proponents of the unitary executive theory on the court, is that any entity that is exercising any level of executive power should be removable from office by the president. And the court has certainly set signals in recent years that it thinks the scope of the universe of agencies that might actually not exercise any executive power is minimal or non-existent.
The justices took pains to point out that this doesn't affect the Fed. The Fed is different.
Yes, that was a really strange little red flag in this decision. It kind of comes out of nowhere in the decision. They might as well have basically said, oh, by the way, President Trump, please don't take this order as a green light that you can fire the chair of the Fed. And they carved out the Fed in like two sentences when it wasn't an issue in the case. And they carved out the Fed by making what is basically a factual observation about the Fed, which is that it is uniquely structured and it has a distinct historical tradition. That is factually true of many independent agencies right now. My own agency that I used to work for, the National Labor Relations Board, that is certainly true. It is uniquely structured and it has a distinct historical tradition. But that doesn't speak to the reasons why the Fed is independent, which are fundamentally similar to the reasons that other independent agencies are independent. The reason that Congress chose to create independent agencies is because it wanted to have entities, even entities within the executive branch, that made decisions based on expertise and that made decisions and were capable of making decisions that might be in the short run politically unpopular, but in the long run in the best interest of the country. And it's very easy to see, of course, how that plays out in the context of the Fed, and particularly when the Fed is wearing its monetary policy hat. It's very easy to see why it's going to have to make decisions that are short-term politically unpopular, but long-term beneficial to the country. But the Fed is not unique in that regard. And one agency that leaps to my mind, for example, is the Consumer Product Safety Commission. Sometimes it is very politically unpopular to find a product to be unsafe or to pull a product off the market, but it might well be in the long-term public interest. So there's not something that makes the Fed distinguishable in a principled manner from other independent agencies when it comes to the reason for its independence.
Let's say the Supreme Court does get rid of Humphreys' executor. What might the repercussions be?
Well, it would depend on how the Supreme Court did it. There's lots of people who predict about these things, and there's a group of predictors who say that they will basically get rid of Humphreys' executor, but carve out the Fed, or at least the Fed in its monetary policy role. I think there's an argument to be made that they could also kind of split the baby in different ways. I think one of the most difficult challenges that we will have in a post-Humphrey's executor world, if Humphrey's executor is swept off the book, is what to do with agencies that are primarily adjudicative, that do business as courts, basically. And it's very hard to imagine how an agency that's supposed to function as a court will function when its adjudicators can be fired for the outcome of individual decisions. So I think there's potentially a chance that the court could also look at the various functions that agencies are performing and say, these are executive and these are not executive. And this order, being a preliminary order, doesn't delve into that at all. But you could have a court that says, well, if an agency is making rules, it is by nature executive because rulemaking is an executive function, but leave open the question, for example, of whether if an agency was truly just a court system, like the tax courts or something like that, whether that potentially could be treated differently. So I think it's a question of whether the court will just wipe Humphrey's executor off the books altogether with some possible carve-out for the Fed and monetary policy, or if it will kind of pick and choose which agency functions it deems to be so executive in nature that the president must be able to control them.
And as far as your old agency, the NLRB, what effect would it have if the president is able to fire board members without cause?
I think it's really hard to overstate how different that would be from the way that the agency operates now. The NLRB and many other adjudicative agencies, like I said, the NLRB does business primarily by deciding cases like a court. And we as judges never had to worry about whether our decisions were going to be politically popular or politically unpopular, or whether we were deciding a case in favor of somebody that the president was friendly with or someone that the president was not friendly with. I think you can see this playing out totally differently in a world where board members, i.e. the judges, could be fired for the outcome of a particular case. You could very much have a system where entities that are closely allied with the president, certain very powerful companies, et cetera, were effectively exempt from the law because, adjudicators would fear for their jobs if they found against them. Conversely, if the shoe's on the other foot and you have a president in office who's extremely pro-union and very closely allied with many labor organizations, there are provisions of the National Labor Relations Act that are enforceable against unions. And you could see that type of enforcement basically fall by the wayside if you have a president that's super union friendly. So it will go from being an adjudicator that jealously guards the integrity of its adjudicative process to being a fundamentally different and political entity where judges are making decisions at the peril of their job based on their predictions about whether they'll face backlash for them or not.
Thanks for joining me, Lauren. That's Lauren McFerrin, Senior Fellow at the Century Foundation. Coming up, we'll look at the latest immigration disputes. I'm June Grasso, and you're listening to Bloomberg.
It's hard to keep up with breaking global business news.
It was a mixed day here in the States.
Volatility is sky high.
But at Bloomberg, our seasoned reporters and anchors make it look easy.
European stocks hit a fresh record.
We consider the lack of motion on Capitol Hill.
Are you worried about a wage price spiral?
A lot of Wall Street strategists getting more and more cautious here.
Listen on Apple CarPlay or Android Auto with the Bloomberg Business app and always on Bloomberg Radio. Context changes everything.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Trump administration is once again appealing to the Supreme Court as it tests the boundaries of the government's power to deport migrants. The Department of Homeland Security is asking the court to block a judge's order that requires the government to give people 10 days' notice and an opportunity to object before they're deported to places other than their home countries. Joining me is immigration law expert Leon Fresco, a partner at Holland & Knight, and the former head of the Office of Immigration Litigation in the Obama administration. Leon, a Massachusetts federal judge ordered the government last month to give people 10 days' notice and an opportunity to object before they are sent to a country which is not their home country. And he said last week that the administration violated his earlier decision.
Well, what happened was this is a case where there are a number of foreign nationals who did commit sometimes very heinous crimes, and they're from Laos, Vietnam, and some other places that don't really accept people that the U.S. is trying to deport back to those countries. And so the U.S. tried to arrange a scenario whereby it could deport those people to South Sudan as part of a diplomatic arrangement it was having with South Sudan to free up some issues, because earlier in the year, South Sudanese people couldn't get visas to travel to the United States. And so this was part of a global arrangement where that would be fixed, and that also South Sudan would agree to accept people that the United States was trying to deport to other countries, not South Sudan. The people who were going to be deported to South Sudan heard about this and said, well, wait a second, I can't be deported to South Sudan. I'm not from there. That's very dangerous. It's a country in the middle of a civil war. And so they tried to file Convention Against Torture claims. And there was actually this case filed in the District of Massachusetts, which was a habeas claim, saying I can't be deported without being given the opportunity to have an adjudication as to whether the conditions in South Sudan are tantamount to torturing me. Because if you just drop me off there, what am I supposed to do? I'm going to starve to death, because, it's not a place where you could just go and get a job and start working. And so that was the claim. And at that time, the district court and the U.S. government were arguing about, well, how do you do these claims? Can you do them where these people were, which is at the moment they're being detained in Djibouti, a different African country where it's just sort of a military operation, and there's not really this ability to long-term have these folks there. There was this debate about where do these Convention Against Torture claims get decided, or do you have to bring the people back to the United States? The federal government didn't want to bring back the people to the United States. It asked that they'd be allowed to make these adjudications in Djibouti. The judge said, okay, fine, I will let you do that. And then after that, the government said, no, wait a second, this is way too complicated. We actually can't do it in Djibouti. And so now the government has gone to the Supreme Court and said, just let us do these deportations. The judge shouldn't be allowed to prevent us from doing this.
The Supreme Court has said that the government has to give people a reasonable amount of time in order to challenge their deportations, but it hasn't spelled out exactly what that means, how much time even. But is this situation different from the cases that the Supreme Court has dealt with? Because these migrants have already been through the immigration system, and there are orders of deportation against them.
Correct. The problem is here, these individuals have an order of deportation that can be executed at any point to their home country, whether it's Laos or Vietnam or whatever. And it can also be executed to any other country, so long as in any of those other countries, there's not a likelihood that these individuals will be tortured. And so the question is, well, can these individuals make that claim? Where can they make that claim? When can they make that claim? How long do they have to make that claim? And does the district court have the ability to interrupt that when a person has already been moved outside of the United States? And I think that's what the debate is going to be, because I think where the federal government is concerned is, what are we supposed to do now that these individuals are in Africa? How do we deal with this? Are we going to be forced to bring them back to the United States? Or will we be forced to actually adjudicate these cases inside of Djibouti, which is where the people are now? Or can we finalize our intentions to deport them to South Sudan? And will there just be prophylactic language in the future about what is required in the future if they're going to do one of these third country deportations? But really, we're in uncharted territory here, and the Supreme Court is going to have to set some standards and some guidelines, because if the federal government really is focused on these third country deportations, then they're going to need to be done in a manner that everybody's comfortable with. And the complication with South Sudan is, just imagine any of us. I mean, if any of us get dropped off in South Sudan, what do we do next? If there's no food, there's no job, if you end up being deported to a place where you know that the solution is just starvation, does that end up violating the Convention Against Torture?
So how do you think the Supreme Court will approach this, given how it's handled the other deportation cases?
The Supreme Court is going to have to decide, where can these individuals make these claims? Are they allowed to make these claims at all? What district court jurisdiction exists here? And I don't necessarily think that the Supreme Court given what we've seen so far, is going to be too friendly toward this concept of not being able to give people an opportunity to make a claim that a deportation to South Sudan is tantamount to torturing them.
Okay, so turning to other cases, ICE appears to be employing a new strategy that it used in arresting a high school student in New York City. Government attorneys are asking judges to dismiss cases against migrants who are there for scheduled hearings, and then waiting ICE agents arrest the migrants and put them in expedited removal proceedings. That's what reportedly happened to a New York City high school student from Venezuela. Leon, so this Venezuelan high school student was in immigration court for a regularly scheduled hearing, and after the case against him was dismissed, ICE agents arrested him. His lawyer says he's here legally, seeking asylum, but the Trump administration says he's here illegally. And apparently this is not an isolated scenario.
What's happening is this. So the Biden administration had this program called the CBP-1 app parole program, which what it said was, don't just cross the border illegally. That's creating a lot of chaos on the southern border. We can't have it. Go to a port of entry, get an appointment to go to a port of entry under the CBP-1 app, and then if we think that you're a legitimate asylum seeker, we'll parole you into the country legally, so you have a legal status while you're here trying to get asylum, and you'll go through the asylum case. So what's happening now is that the Trump administration is saying for all those people who had been let in legally to do an asylum case in immigration court, we are going to cancel your legal admission. We're going to close that case, and we're going to pretend like none of that had happened, and we're going to put you in expedited removal, which says that if you are here for less than 2 years and you never had a legal basis for coming, you can be removed on an expedited basis. But what that requires is for the person to be arrested, and then they have to have a new adjudication as to whether they have a credible asylum case. And if they don't, they can immediately be removed. But if they do, then they're basically back at square one, which is the same immigration court hearing that they were arrested at minutes ago. So this Bronx student was in exactly this situation where they were let in legally under the CBP-1 parole app, but now they're arrested, placed in expedited removal proceedings.
And this type of scenario is being played out in immigration courts across the country.
So there's basically three goals of this. Number one is maybe 20-25% of the people that they're going to do this to won't actually be able to show that they have a credible asylum claim. And so with that group, they can just remove them outside of the United States. And so that increases the removal number. So that's goal number one. Goal number two is, to the extent people are now scared to go to immigration court, when you don't show up to immigration court, you get what's called an in absentia removal order, which is you basically lose by default. You get ordered deported, and that's the end of it. And as long as the government can show that you had notice of the hearing, then that's it. You know, unless there was some earthquake or some bridge collapsed or something, and that prevented you from going to the hearing that day, you're pretty much in a bad position there. But the government then, if they get these in absentia removal orders, can also try to execute those, and that also is easier than trying to win a removal order in a hearing. So that's a second reason to do this, is people stop going to court. They get in absentia removal orders. You can deport them more easily. And then the third is people will be so afraid about finishing this process, they'll just take matters into their own hands and go home. And so that's really the purpose of this, is to create this level of fear that people either don't show up to court and they get ordered deported, or they go home. But if they do go to court, they're going to get arrested. If you haven't been in this country for more than 2 years, what will happen is you will be arrested and put into these expedited removal proceedings. And what that will do is, for some segment of the people, they will be deported immediately. For a larger segment, let's say 70-75%, they will be placed back into the same proceeding they were supposed to go to court for that day. but after having been arrested and detained and having to pay out a bond. And so all of this is very scary and unsettling, and that's part of the strategy, is to impose those kinds of conditions to make it as onerous as possible for the people here without status to remain here.
So then will this student definitely get a hearing?
Well, so they will first have to show that they have a credible asylum claim. And, of course, because the student is from Venezuela, it probably will not be that difficult, because Venezuela does crack down on political dissidents, and this person can show that they had some political oppression in the past or they have some political issue. They can clear that threshold, and then they'll actually have an asylum hearing, which was the whole purpose of why they went to court in the first place.
Thanks so much, as always, Leon. That's Leon Fresco of Holland and Knight. Coming up next, the courts are split on geofence warrants. I'm June Grasso, and you're listening to Bloomberg.
Breaking political news from the team that knows D.C.
A breaking story. Greg Stohr, Bloomberg Supreme Court reporter, with us.
Joe Matthew and Kaylee Lines, along with D.C.'s most respected news team.
Nick Wadhams, he leads our U.S. national security coverage at Bloomberg.
Balance of Power with Joe Matthew and Kaylee Lines.
We welcome Gregory Cordy, Bloomberg Politics reporter.
Listen live weekdays at noon and 5 p.m. Eastern, or on demand wherever you get your podcasts. Bloomberg Radio. Context changes everything.
This is the Bloomberg Green Report. The World Meteorological Organization is downbeat. It predicts human-made climate change will continue to warm the planet, and we'll see new temperature highs over the next 5 years. Furthermore, the WMO sees an 80% chance that at least one of the next 5 years will be hotter than 2024, which was the hottest year ever for planet Earth. The report says the world's average temperatures will be between 1.2 and 1.9 degrees Celsius higher than the average in pre-industrial times, and the warming will increase extreme weather events that will impact ecosystems, societies, economies, and people's daily lives. Co Barrett, the WMO's Deputy Secretary General, says unfortunately the report sees no sign of respite over the coming years. Forecasters say every fraction of a degree of warming will lead to more intense, frequent, and harmful heat waves, extreme rain, and drought. Jeff Bellinger, Bloomberg Radio.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Geofence warrants are relatively new. Google received its first in 2016, but the use of such warrants has proliferated, as have court cases challenging them. Unlike a warrant authorizing surveillance of a known suspect, geofencing is used to identify would-be suspects. Google has been the primary recipient of these warrants due to its extensive location history database. Federal courts have split on whether these geofence warrants are constitutional. But now New Jersey State Court has ruled that police use of geofence warrants does not violate constitutional privacy protections and is not an impermissible general warrant. Joining me is Alex Ebert, Bloomberg Law correspondent. So, Alex, tell us what a geofence warrant is.
A geofence warrant is a broad warrant that allows police to find out who may have been in a certain location at a given time. So imagine you're the police and you're looking for, people, let's say at the Capitol riot on January 6th, and you want to find out, hey, whose cell phones might have been present around the Capitol when things started going down? Or let's say there was another event where we have a riot after there's a police shooting. Hypothetically, police officers could find out who was in the vicinity of a building when it got broken into. That's the sort of information that police officers can be looking for.
So what is the question when using a geofence warrant? Is it privacy concerns? What are the constitutional concerns?
That's right. So this all boils down to privacy. And there's two sort of big questions that courts are grappling with. One, is this a general warrant that would violate the Fourth Amendment protections we have against the police invading our privacy? And two, would this be considered the stuff that we don't really have an entitlement to protect because it's held by third parties? This is an issue that courts have grappled with for decades, and it gets only more complex as more of our data is being given to third parties.
Tell us what happened in this case, the facts of the case.
Sure. So this case involves a Milltown robbery. Basically, what happens is someone came into a convenience store or gas station late at night, and the clerk who got assaulted heard someone talking on the phone. That was really all the police had to go off of in this case. And so because they knew there was a phone conversation going on, they went to Google and said, hey, was there anyone in this particular area, usually it's a couple blocks, that was making a phone call or accessing their phone at this given time period? They went to Google, and Google found only one identifiable person that was there. And from there, the police officers were able to request from Google, demand that they provide the identification of that Googled user.
And so explain what the court found here.
Sure. So the New Jersey Court of Appeals was extremely divided, as other courts have been in recent times, on this issue. The majority found that this is okay, that there's a process through which the police here are requesting information from Google, and they're narrowing it down based on the location and the time period that they're seeking pings on people's cell phones. And from there, it's fine. It's articulable suspicion. We've got the probable cause necessary to get this information in a warrant. But the dissent here is saying, no way. What we're asking for here is to hoover up all this information, and you're able to tap into whomever might be in this location at a given time, whether or not they might be related to this crime or not.
This New Jersey case is a case in state court, but the federal courts are split on this. The Fourth Circuit, sitting en banc, couldn't produce a majority opinion explaining why they allowed the Geofence warrant, so it issued 8 separate concurrences.
It is such a mess, June. So we have that court going that direction. And then we have the Fifth Circuit, what we would consider to be extremely conservative, going the complete other route. So we have this circuit split where we have a court that says, this isn't a search at all. This is information held by third parties the defendants aren't entitled to protection over, right? Then we've got the Fifth Circuit saying, this isn't just a search. This is an unconstitutional general warrant. This is the thing that, we created the Fourth Amendment to stop. We don't want the British officers coming in and ransacking our houses, just generally looking for stuff. And that's what you're trying to do here with these general warrants of disinformation to Google users. And just pulling it back, we're talking about hundreds of millions of devices in the United States. Hundreds of millions of people have access to just Google's accounts. And so if you're looking at the split here, it's the difference between, can we get at that private information that's held by these service providers, by these apps, or is that just too much data? Do we have an updated, sense of privacy that is being invaded here?
Do you have any idea how many of these geo warrants are issued in a year?
I haven't been able to find information on how many it is. However, when I've spoken with attorneys off the record, they've told me that it's increasing again and again and again because it's becoming more valuable information. We also have other courts considering this issue right now. Just last month, the Texas Criminal Court of Appeals, which is their highest level of criminal courts, they allowed geofence warrants. And the Minnesota Supreme Court is considering right now a case on the constitutionality of geofence warrants. So this is bubbling up across the country.
Could this be appealed to the New Jersey Supreme Court?
Indeed. So because this is a divided decision in the Court of Appeals, the New Jersey Supreme Court will automatically grant review if the loser wants it. That is a certainty here. This is going to be a huge case, and you're going to see, amicus briefs from all over the country pour in on this thing because there's so few of these decisions that are either bubbling up or at that highest court level. And in particular, New Jersey is extremely strong in Fourth Amendment terms, and it has interpreted both the federal Fourth Amendment, and its own privacy protections broadly for criminal defendants.
Google is implementing changes to encryption. Explain what they're trying to do.
That's right, yeah. So it's been over a year now since Google has announced that it's going to be implementing changes to encryption that would prevent somewhat, some of these broader geofence warrants. We're talking about, instead of Google storing this information, it will be stored on a local device. Or it will be, encrypted in such a way that even Google can't read it, and so it can't turn over account information to police officers. But that's not necessarily going to stop this, either for Google or for other apps. If you think about it, there's other warrants that, could function well beyond this, right? So if you're taking an Uber somewhere, why can't the police say, hey, Uber, give me all of the rides that, came into this block, right, or this series of blocks within the 3 hours the night of April 25th? Or Facebook or Apple, were there any location tags or people that bought things, using Apple Pay or whatever within a certain radius around here? It's not just Google that, defendants might have to worry about. And beyond that, you could even think of ways where you can get at this sort of information without really looking at, pinging from someone's location through geolocation. What if you could go to Google and say, hey, give me anyone that searched for, the victim's house or areas around there in a certain time period? So you can think of creative ways where the police could really use an expansive access to these geofence warrants to look for information, even outside of what Google is trying to prohibit.
Has the Supreme Court taken up any case that's similar to these geo warrants?
Not exactly on point, June. So over the course of my lifetime, the Supreme Court has gone from a more favorable access to third-party data to a less favorable access to third-party data framework and stance. In 2018, we had a Carpenter case, which is about the pinging of cell phone towers, right? And there, the Supreme Court made sort of a great ruling for defendants that, hey, police have to get a warrant to get access to this. You can't just hoover in this information. But there's nothing that's on this level that involves this kind of technology and this kind of warrant.
And how's the privacy bar taking this case?
Privacy rights attorneys are really up in arms about this because of the huge implications here. And, for the creative ways that it could be used, oftentimes these sort of maneuvers aren't really discovered until months or years after, police are looking for this information. But at the same time, police officers say, hey, we didn't have anything on this guy, that committed this robbery. There's no CCTV. There's nothing really that would have given us this lead. And so on one hand, you have this extremely powerful tool for police officers. And on the other, you have this really scary sort of invasive ability to look into what we're doing on our phones.
I'm sure we're going to hear more about these warrants. Thanks so much, Alex. That's Bloomberg Law correspondent Alex Ebert. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast wherever you get your favorite podcasts. I'm June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.